creativity. Proudly brought to you by the Nigeria Copyright Commission, NCC. My name is Tolu Adepoju. Together we will navigate this cruise ship called Copyright Connect today. All we ask of you is to sit back, relax, enjoy every bit of today's program. It's an enlightenment session, and don't forget you can be a part of today's program by joining us live on Facebook at Oxygen 96.9 FM. You can join us on Instagram, Oxygen 969 FM. You can join us on YouTube, Oxygen 96.9 FM Ibadan, and on TikTok, Oxygen 96.9 FM Ibadan. Should I take that again? Yes, let me go again. You can join us live on Facebook at Oxygen 96.9 FM. Join us on Instagram, Oxygen 969 FM, on TikTok, Oxygen 96.9 FM Ibadan, and on YouTube, Oxygen 96.9 FM Ibadan. Whether you're listening from your home, your studio, your shop, your office, or you're traveling, you're on the road, you can join us. Tune in to Oxygen FM 96.9.
Okay, here we go.
Oxygen FM 96.9 Ibadan.
Last week we began our two-part series on your right as a copyright owner. What can you control? We explored the bundle of rights that protect literary, musical, and artistic works. We explained how copyright owners control everything from reproduction and publication to adaptation to communication to the public and their important moral rights. Let me remind you again, we talked about the bundle of rights that protect literary, musical, and artistic works. We explained how copyright owners control everything from reproduction, publication, adaptation, communication to the public, and their important moral right. Today, we will conclude the series by focusing on three major pillars of Nigeria's creative economy. Number one is the audiovisual works such as films, television programs, documentaries, and music videos. The other part is sound recordings, which are the actual recorded performance of songs, podcasts, and other audio content. And the last part of today's program will be broadcasts, including television and radio transmissions. Again, audiovisual works such as films, television programs, documentaries, and music videos. The other part is sound recording, which are the actual recorded performances of songs, podcasts, and other audio content. And lastly, broadcast, including television and radio transmissions. Before I move on, let me quickly do a recap of last week before we continue. Here's a quick recap. Last week, we emphasized and explained that copyright is not just one single right. We said that copyright is a bundle of exclusive rights. Some people call it economic right. Exclusive right that gives creators control over their works which are used. Depending on the type of work, copyright owners may control reproduction, they may control publication, public performances, broadcasting, communication to the public, adaptation, and translation, and online availability. Today, we will see how these rights, the set of rights, apply specifically to filmmakers, to music producers, to recording artists, and to broadcast organizations. Joining us once again in the studio and from Abuja is our copyright expert from the Nigerian Copyright Commission. Is the Director of Planning, Research and Statistics of the Nigerian Copyright Commission, Collins Nweke, from the Commission's headquarters in Abuja. Good morning and welcome to Copyright Connect on Oxygen FM 96.9.
Thank you. It is wonderful to be here again as we conclude this important conversation on what creators actually control.
Thank you very much. It's good to have you again. Last week we had a lot of questions, and today my guest on the program will be giving us answers to all those questions at the right time. But let's quickly look at the audiovisual works under Section 11 of the Copyright Act 2022. This includes Nollywood movies, documentaries, television programs, and web series. What rights does the copyright owner enjoy in this category?
Yeah, under the Section 11 of the Copyright Act 2022, the copyright owner of an audiovisual work has the exclusive rights to control reproduction of the audiovisual work. That is to say, control the recording, copying, uploading, or downloading of the audiovisual work. So that is number one. So number two, exclusive right of control that the audiovisual work owner has is to control the showing or playing of the audiovisual work in public. So number three is transmitting the control that exclusive right to control the communication of the work to the public. In other words, transmitting the audiovisual work to the public. So, such as, for instance, streaming films in a hotel room, for instance, is a form of communication to the public.
Yes.
So, number four, exclusive right of an audiovisual work owner is the right of broadcasting the audiovisual work
either on television or radio.
Yes, either on television or radio. For instance, when NTA transmits a movie or soundtrack to viewers across Nigeria. So now the number five exclusive right of audiovisual work owner is making copies of his soundtrack. And the number six, making the work available online so that people can access it whenever they choose. Now, this making work available online. Yes, it's essentially in the form of maybe streaming a movie on a video on demand platform or even in the YouTube and all of that. So the number six right of an audiovisual work owner is number seven, is the commercial distribution, the right to commercial distribution of copies through sale or other authorized transfer of ownership. The number eight, and of course the last right of an audiovisual work owner is what we call the right of translating the work or adapting the work. So in terms of translating the work, for instance, we are talking about rendering the dialogue, narration, subtitles, or soundtrack of the original audiovisual work into another language. Example is a film originally produced in English is dubbed into Hausa for audiences in Kano, Katsina, and other Hausa-speaking audience. And then in terms of the adaptation of the work, when we talk about adaptation, we're essentially talking about when an audiovisual work is transformed from the original audiovisual work into another form while retaining substantial elements of the original expression. The example is turning a Nollywood film into a television series. Thank you.
Okay, thank you so much. Please go ahead.
So what this right essentially does is to ensure that creators of audiovisual works, remain in control of how their films and audiovisual contents are used commercially. Thank you.
All right, thank you. Collins Nweke is the Director of Planning, research of the NCC in Abuja. Now let's turn to sound recordings under section 12. We just dealt with section 11. Now let's go to sound recording under section 12. This applies to music producers, record labels, podcasters, and independent recording artists. What exclusive rights do they enjoy, or do they have any exclusive right at all?
Yes, of course they do, because every owner of any type of copyright protected work do enjoy that exclusive right. So in the case of sound recording, for instance, it is the owner of that copyright in a sound recording has the exclusive right to control the production of the sound recording. For instance, whether it is in form of downloading the sound recording, duplicating the sound recording, making copies of the sound recording, those are all forms of reproduction of the sound recording, which the owner of that sound recording has the exclusive right to control. In other words, he can decide to authorize or prohibit authorize somebody else to reproduce the work, or prohibit people from other people from reproducing the sound recording. So that's number one, the right of reproduction. Then the next exclusive right of a sound recording owners is the right of broadcasting the sound recording, which of course is for instance, a copyright owner has the exclusive right to authorize or prohibit the broadcasting of a sound recording, subject to exceptions under the law and subject to applicable licensing arrangements. So the number three right of exclusive right with respect to sound recording is the right of communication of the sound recording to the public. Then number four is the right of making the sound recording available online, so members of the public can access it whenever and wherever they choose, including through
licensed digital platforms.
Streaming platforms. What is involved here is essentially that the listener decides when and where to access the sound recording, in terms of this making available, so the copyright owner of sound recording works, controls that particular right of making available. And then the next bundle of exclusive rights is for sound recording is commercial distribution of copies of the sound recording through sales, rental, lease, hire, loan, or other similar arrangements. Now, these rights ensure that creators and right owners decide how their sound recording are commercially exploited, meaning that they can either authorize somebody else, to use the sound recording in any of these ways, or prohibit a third party from making use of the sound recording in any of these ways that I have outlined. Thank you.
All right, thank you, Collins Iweke. And something actually, my next question, one issue many musicians ask is about royalties. When songs are played on radio stations and are used publicly, what does the law say? Because, okay, we can hold radio stations, television stations liable. What about in public places such as filling stations, in motor parks? What does the law say?
Yeah, this question is very interesting because this is substantially addressed under the Section 15 of the Copyright Act 2022, which essentially, means that where a commercially published sound recording is broadcast, both the performer and the owner of copyright in the sound recording are entitled to equitable remuneration. So in practice, this remuneration is generally administered through collective management organizations in accordance with the Copyright Act. And collective management organizations are associations, organizations that are set up, of course, approved by the Nigeria Copyright Commission to essentially negotiate the use of copyright work of their members, with a third party, and then collect royalties and then distribute that royalty to their members. Thank you.
All right. Thank you so much. You've not totally answered the questions. Yes, we know there are collective management organizations in accordance with the Copyright Act will go about these organizations, radio stations, television? What about these filling stations and motor parks? Who ensures that royalties are paid or they are made liable to pay royalties to musicians for using their songs?
Yeah, essentially it is the work of CMOs, collective management organizations, because they are the one that entrusted, that are the law entrusts with that function of collecting royalties and distributing to their members. But however, individual rights owners can also take steps if they see that their work is being used in their sound recording is being played in a motor park and all of that. They can also take action. But one thing about taking such of action is that the individual rights owner ordinarily is unable to know to know everywhere their work is being used. So usually we advise that they concentrate on their creative production while they give the rights, of
to CMOs.
To CMOs who has enough time to do that. They cannot be going from one park to another chasing people, but definitely CMOs can actually do that on their behalf if they belong to that CMO.
Okay.
Thank you.
In case you're just joining us, the program is Copyright Connect on Oxygen FM 96.9. My guest has been Collins Nweke, the Director of Planning, Research and Statistics at the Nigeria Copyright Commission headquarters in Abuja. We're moving on to the final category. Don't forget, if you're following us, we have talked about the Section 11, which deals with the audiovisual. We'll talk about Section 12 with the recording. Now we are moving on to broadcast under Section 13. Radio and television stations invest significant resources in producing and transmitting programs. What rights does the law give broadcast organizations?
Yeah, under the Copyright Act 2022, the law grants broadcasting organizations a bundle of exclusive rights to control the rebroadcasting of their broadcast. And when we talk about the broadcasting, we are talking about a situation. It involves essentially one broadcaster receiving the original broadcast and transmitting and retransmitting it to the public. This right seeks to prevent unauthorized retransmission of a broadcaster's signal. Now, the number 2 bundle of exclusive rights for broadcasting organizations is the communication of their broadcast to the public. So the law authorizes them to, control, the communication of their broadcast to the public. Nobody else can do that except they have the permission, the requisite permission to do that. Then the number 3 bundle of rights for broadcasting organizations is the right of making broadcasts available online, to the public, either by wire or wireless means, in such a way that members of the public are able to access the work from a place and at a time independently chosen by them. So, for instance, we're talking about all this kind of video on demand access to broadcast programs where you can actually, tune in at any time you want and at any place you want and with any mobile device you want, and you're able to listen to some programs, So now the 4th right that broadcasting organization has is the right of recording or fixing broadcast onto storage media. So nobody else has the right to record or fix broadcast on any storage media, be it in CD, be it in any storage media whatsoever, without the authorization of the broadcasting organization to whom that right belongs. So the next right is the right of reproducing the recordings of the broadcasting organization. And this essentially means making copies. Whatever way of making copies of that broadcast is prohibited except with the authorization of the broadcasting organization. Then the next right is making the right of making an adaptation of a recorded broadcast. In other words, adapting the recorded broadcast. So it is only the broadcasting organization that does the broadcast that has the right to make an adaptation of its recorded broadcast. And when we talk about adaptation here, it refers to when a recorded broadcast is transformed into a new or modified version while retaining substantial elements of the original. Example is adapting a recorded children's television program into an animated version. Thank you.
Or adapting a radio program into television.
Exactly. For instance, a radio station. A radio station can. A radio station can decide to, can decide to. A radio station can decide to adapt a recorded program of that of another radio stations into an animated version, but that can only be done with permission of the
original owner.
Exactly.
Now, talking about broadcast, because this is our jurisdiction, our domain, it affects us. I'm looking at a situation whereby one radio station has a program. Another radio station now decides to do the same program with the same name, with the same title. Is there an infringement?
Well, it depends.
Okay.
Well, it depends is that if they are not, it cannot be seen, to copy what you have done verbatim. In other words, to replicate what you are doing verbatim. Then there won't be any this thing. One thing about copyright is that two different persons can create the same work in a different way.
Okay.
You have the same title. For instance, in the case of literary work, for instance, somebody may write a book about Eze Goes to School, and another person may also write a book about Eze Goes to School also. But now, the problem becomes, the problem comes in if it is determined that the first one, or rather the second one, copied, apart from the title, copied verbatim what the first writer has in
his book.
Her own. Yes. So if there's no evidence of verbatim copying, for instance, or if the two does not look, confusingly similar, then each person will retain their own copyright because
originality.
It can be said that it is
okay.
Yeah.
Okay. All right. Thank you for the clarification. Now, it is important to remember that the broadcast signal enjoys its own copyright protection, separate from the copyright that may exist in songs, film, and other content carried within that broadcast. Now, we'll take a break, and when we come back, we'll give you the copyright tip for this week, and then we'll move on to some of our questions for our guest on the program, Collins Nweke from Abuja. Okay, in case you're just joining us, you're tuned to Oxygen FM 96.9 and the program is Copyright Connect. Here is the copyright tip for the week. Whether you're a filmmaker, you're a musician, or you're a broadcaster, your digital rights are extremely valuable in today's online economy. Please ensure that whenever your work is uploaded on streaming platforms, website, or social media, there are clear licensing arrangements governing its use. If you discover that your work has been uploaded online without your permission, the Copyright Act provides a notice and takedown procedure that enables eligible right owners to request the removal of infringing content from online platform. Let me take that again. It's a copyright tip for this week, and it is useful for everyone. If you're a content creator, you're a broadcaster, you're a recording engineer, whether you're a filmmaker, musician, a broadcaster, or digital rights, you have rights that are extremely valuable in today's online economy. Ensure that whenever your work is uploaded to streaming platforms, websites, or social media, there are clear licensing arrangements, very clear licensing arrangements governing the use. If you discover that your work has been uploaded online without your permission, the Copyright Act provided notice and takedown procedure that enables eligible right owners to request a removal of infringing content from online platforms. Now, these questions. Collins Iweke, you are still there?
Yes, I'm here.
Now, let's look at some of the questions that were sent in. When an artist, this person says, my name is Jide, and my question is this. When an artist signs with a record label or a publisher, what rights are they giving up? And how can they negotiate to keep more control?
Okay, you see, this again, I would say it depends. Because when an artist signs with a record label or music publisher, they do not necessarily lose ownership of all their rights. Instead, they grant certain exclusive rights in exchange for instance, funding, marketing, distribution, and promotional activities, by the local label. So the exact right will depend on the nature of the contract that both of them entered into. And in that regard, it's important for the rights owner to understand, what rights are transferred, and that is why this program is very important, so that rights owners can actually rights owners in the different categories of copyright works can actually know the right that they have. So, so essentially the artist still has all the bundle of exclusive right that the law has granted to the artist can still be retained by the artist. But what is important is to find a strategy, that enables the artist to ensure that he or she does not sign out all their rights.
Now,
through good negotiation, for instance, they could be able to retain, substantial part of those rights, and then give, the necessary rights that the legal label requires to them. So that, for instance, if in a agreement, for instance, you need to be very clear on, for instance, the type of rights. There's nothing that says, some people make the mistake of assigning all their rights,
they sign them over.
Yes. They are assigned all the bundle of economic rights to them, and then they come back maybe 1 year or 2 years ago and start finding that they have shot themselves on the leg. So what usually happens is that you ensure that you assign some of them, essentially those ones that this thing actually needs. For instance, the right of we have some cases whereby some people even sign their future works to legal labels, meaning that even the produce in the future will still belong to the legal label. So what is important to do is that they find a way to strategize in the agreement that they will have. So, for instance, they can assign the right of reproduction, or rather, they can retain the right of reproduction, but give exclusive right of reproduction to the legal label, and then they can attach a duration, to that exclusive right also. For instance, they can say after 2 years or after 3 years, the right reverts back to me again.
Okay.
Yeah, yes. Okay. Or they can also limit the coverage of that right. For instance, they can say, okay, I give you this exclusive right over my right of reproduction, but it can only be used in television and radio. It cannot be used in social media platforms. Okay. Yeah. I can also say that I give you the right of reproduction, exclusive right of reproduction, but it can only be used for a period of 3 years and only within the Nigerian territory. You cannot use it outside Nigeria, even internationally. So these are some of the ways that the rights owner can ensure that they are not
giving up everything. All right. Thank you so much.
Yeah, so these are some of the strategies they can use. Yeah.
Now,
so make sure you don't assign all your work. Make sure you don't assign all your future work. And if you are in doubt, you bring in a lawyer to help you.
Let's quickly take the next question. Let's quickly take the next question. This one says, if someone uses my work on Cynthia, if someone uses my work on TikTok, YouTube, or for an event without my permission, what level of control do I legally have to stop them or get paid?
Yeah, in the first instance, nobody else has the right to use their work on TikTok or YouTube without the authorization of the rights owner. So, what you can do, what the rights owner can do in this case, is to first of all, from time to time, you scout, the digital environment to see where your work is being used, and also to determine whether that person has the authorization to use that work. If the person does not, you can first of all write a cease and desist letter, to that TikTok account or YouTube account, and informing them that this work belongs to you and they don't have any right, to do what they are doing. Then, if that fails, you can also write a takedown notice. You can also give takedown notice to TikTok or YouTube. As an ISP, as an internet service provider, letting them know that this work belongs to you and all of that.
And no permission has been taken from you before use.
Yes, has been taken from you for uploading this on their TikTok or YouTube channel. So you can also contact the Copyright Commission. Copyright Commission has a stop, where what we call stop.
STOP.
Which essentially means, yes, STOP, stop. Which is a platform that the Commission created that is that requires concerted efforts of every rights owner and every person that uses copyright to team up with the Copyright Commission.
Collins
to ensure that, yeah.
Collins, because of our time, let's quickly take this one. It's very important. It says, hello, Copyright Connect. Thank you for the good work you're doing. I'm an editor and I'm a content creator. With the AI, what should the law do? What would the law do about it? He said, do you think copyright owners are losing control with AI? Okay,
no, actually, they are not necessarily losing control. Copyright has faced many challenges over the years, with the advent of new technologies and all of that. So copyright owners are actually facing increasing challenge in controlling the use of their works in AI training, for instance. But they are not necessarily losing their rights. The main challenge is that when most of these Copyright Act laws were made, that the modern generative AI was not anticipated and all of that. But for any future reform or legal reform, the aim should be to prohibit AI. The aim should not be to prohibit AI development, for AI has come to stay. And the aim should also not be to permit unrestricted use of copyrighted works, for instance, in AI training. A balance should be drawn, whereby the law creates a balanced framework that promotes innovation while preserving the fundamental principles of copyright, such as authorization, attribution, where appropriate, and fair remuneration. So increasingly, copyright owners are demanding that those who create AI, and who uses a copyright words to train their AI, that they should pay royalties, And on the side of the AI creators also, they are saying that, that they too are creating new things and all of that. But the important thing to note here is that there is no AI that does not use copyright protected content, because AI training usually involves huge trove of data, which involves copyright protected works, such as text and video and all of that. So what the law should aim is to draw a balance whereby both does not work against the other one. Thank you.
Thank you so much, Collins Nweke. You've really, really dealt with some of the questions we have on the program, but we still have more questions. But I'm not sure whether we are going to continue this particular topic next week. But so quickly, should there be a time when copyright owners' control expires for public good? What's your view on the balance? Quickly.
Yeah, essentially, part of what the copyright law does is to draw a balance, between the interest of the right owners to continually demand for increased protection, and of course, the interest of the general public or the users of copyright work to have access to copyright works. And so that is why most copyright laws usually provide for exceptions. So that exception is aimed at drawing that balance, and of course, don't forget that copyright does not last in perpetuity. Every copyright work usually expires after a given period of time. For instance, literary artistic work and musical work are usually 70 years after the death of the author. So there's already that kind of control that is inbuilt because copyright laws all over the world essentially seeks to balance the interest of the copyright owner and the interest of the users of copyright works. Thank you.
All right, thank you so much. Collins Nweke is the Director, Planning, Research and Statistics at the Nigeria Copyright Commission headquarters in Abuja. Before we go, let's quickly go over some key takeaways. Copyright owners of audiovisual works control reproduction, public exhibition, broadcasting, communication to the public. Copyright owners of sound recordings control reproduction, broadcasting, communication to the public, online availability. Another one is that performers and sound recording owners are entitled to equitable remuneration when commercially published. Now, call to action. Understanding your right is a first step towards protecting, commercializing your creativity. It is your responsibility. Understanding your right is a first step towards protecting and commercializing your creativity. If you need guidance on copyright protection, recordation of works, licensing, dispute resolution, or other copyright services, the Nigeria Copyright Commission is there to help. You can reach out to NCC through email info@copyright.gov.ng. The phone numbers are +234 901 900 1400 or +231 901 900 1401. Public Affairs Department hotline is +234 707 117 0512. Until next week, my name is Tolu Adekboju. Many thanks to Folakemi Tokunbo Ishola, my producer, Bayo Adewoyin and his group of IT guys, Florian Adedayo. Thank you so much, and a big thank you to NCC for bringing this program about. Good afternoon, good morning. Thanks for listening.